reporting back to the Supreme Court finally convinced the Supreme Court that they needed to apply the writ of continuing mandamus, which was established in the Vineet Narayan case, that's the Jain Hawala Diaries case, and they continued to monitor the Gujarat trials. What else did we manage to do? In 2004, on April 12, 2004, for the first time in Indian jurisprudential history, the Best Bakery judgment was delivered. This judgment also is worth reading because it's a trajectory of the kind of violence that took place in Gujarat, strong language used when Gujarat was burning, Neros were fiddling, etc. But apart from the dramatic language, the important thing is that the court recognized that the prosecution was acting as defense counsel, that the relatives of the accused were being called as witnesses by the prosecution, and transferred the case from Gujarat to Maharashtra. That was our plea. Now this judgment, the Best Bakery judgment as it's famously known as, for the first time flagged the issue of the absence of witness protection. The only one judgment in the Supreme Court had done it before that was the Sakshi case related to the women's movement and domestic health, the domestic workers movement, where the women's movement had pointed out that if you don't have adequate witness protection, you cannot expect witnesses to remain true to their testimonies. So that's the third issue that India needs to look at but is actually delaying looking at. That a robust witness protection program needs to be in place for criminal trials to succeed, particularly when religious minorities are involved. So we managed to use the NHRC report successfully. We managed to get not just Best Bakery case, but Bilkis Bano case also got transferred thanks to NHRC intervention. Bilkis Bano case got transferred to Gujarat, from Gujarat to Maharashtra. In both these cases, convictions happened where there had been acquittals earlier. And very importantly, in May of 2004, the Supreme Court ordered protection for 570 witnesses of the Gujarat carnage. Please understand this, it's very important. People don't know it. 570 victim survivors who are also eyewitnesses, living in far-flung villages in Gujarat, apart from me, have been given 24-hour paramilitary protection. This has never happened in the history of Indian jurisprudence. And but for this witness protection, Modi winning the election 3 times, do you think it was likely that the success we've had in getting 127 life imprisonments, we have managed to get 127 life imprisonments in these 9 cases. It's history being made. You don't get convictions in normal cases. Sardarpura, apart from Best Bakery and Bilkis, Best Bakery the judgment came in February 2006, Bilkis Bano the judgment came in January 2008 in Bombay. I won't get into that because they were outside the state. But even even within Gujarat, November 9, 2011, 31 people convicted to life imprisonment in Sardarpura massacre. What was the Sardarpura massacre? Sardarpura massacre was when in a small village in Mehsana district in North Gujarat, 2 days after the Godhra train burning, 33 people, mostly women and children, Muslims of the Sheikh community, are burnt alive by the Patels of the village. There's sufficient warning. They are crying for help for 2 days, yet the police does not act. That is one of the cases CJP took up. We came right up to the Supreme Court. We got the witness protection. We got lawyers to assist the prosecution. I mentioned at some point when I was talking that the state is the main prosecutor in India, in Anglo-Saxon systems of jurisprudence. One of the recognitions, thanks to international law, and also domestic experience has been that unless victimology is also factored in, victims' rights are factored into criminal law, you are not going to get justice. It's an international recognition today. One of the things we managed, when I say we, I mean India in general, Indian Parliament passed in 2009, January, an amendment to Section 2482 of the CRPC. And the Section 2482 of the CRPC allows victims to appoint their own lawyers to assist the prosecution. This was a legislative recognition of the experiences of Gujarat 2002 justice struggle. In 9 of the cases that the SIT was investigating and our organization was involved with, 9 criminal trials, we appointed 3 lawyers each. Young people like you, every day to sit in the trial, assist the victim survivors, read their statements, not get misguided by the defense, not get misguided by the court and the processes which are very onerous. But for this rigorous engagement, we would not have got the conviction of 31 people on 9th of November 2011. Now please understand, the small village in North Gujarat, case going on in the district headquarters at Mehsana. Who are the victims? They are daily wage earners. Please understand the socio-economic structure. They are daily wage earners, they are agricultural laborers. And who are the perpetrators? They are the Patels of the village, powerful landholding community. And yet, despite the fact that the political forces backing the Patel is in power in the state, we managed to get a conviction of 31 of the Patels simply because of these factors at work. Witness protection, Supreme Court monitoring, and rigorous legal assistance to the victims. Most importantly, when the Godra judgment was given in February 2011, 7 months before this judgment, very gleefully the SIT and the state of Gujarat tom-tommed the death penalty. Please understand this carefully. Out of the 31 people convicted in the Godra train burning incident, 6 have been given death penalty. They are on death row. As a matter of principle, in all the post-Godra cases, we had long discussion with the victim survivors, long debates, and we managed to convince them that we will not ask for death penalty. Though the cases were as heinous, they fit the qualification of rarest of the rare. But yet we on principle in our written argument said we do not want to ask for death. So this is a huge movement forward. It's not simply a movement forward in terms of the number of convictions and acquittals, but in terms of the quality of jurisprudence, in terms of principled jurisprudence. That was Sardarpura. Then we had 2 judgments in Ode. Ode is in Anand district, where we had over 40 convictions. Then we had the most historic judgment on 29th of August 2012 in Naroda Patia verdict, where again 31 people were convicted, including a former minister, a woman, Maya Kodnani, a woman who was a gynecologist by profession, who shamefully on 28th February 2002 was distributing swords to young men to tell them to rape and kill Muslims in Narodabad. But she has been convicted to life imprisonment. So has Babu Bajrangi. So have other masterminds. But our major case, after all these successes, 127 life imprisonments related to Gujarat 2002, humbly I'd like to say it's never happened before in the history of Indian communal violence. It didn't happen in 1993 Bombay. It didn't happen in 1984. But we have managed to get 127 life imprisonments. And there are some lessons to be learned here collectively so that we ensure that violence becomes a preventive. So why eventually do we want convictions? Why do we want to prosecute? not for some retribution, but because you want to ensure that the rule of law becomes the norm, and a certain message goes out in society that such violence will not be allowed. A few more words before we take a small break for discussions. A few words I'd like to say on the Zakia Jati protest petition, which is underway at the moment, which is in a way the mother of all these cases, because it actually links up the criminal conspiracy behind all these individual outbreaks of violence that took place. But in the process of which we managed to access 40,000 pages of documents, 40,000 pages of documents which include intelligence reports, police control room records, statements, government of Gujarat files, etc., which tell us and have unfolded a story of semi-conspiracy, systematic subversion of the system, which we are arguing on a thrice-a-week basis, and we expect our arguments to finish by September 5th, and any time after that the judgment could be delivered. Regardless of our success or failure at the magistrate court stage, but I'm sure that at some point we'll get success, the jurisprudence that has unraveled through these cases, the strategies that have unraveled through these cases tell us 4-5 things. I'd like to repeat those 4-5 things before I wind up for a bit, and then we can carry on later. 1, you will not get justice in minority rights cases within India unless you ensure some monitoring by the judiciary. Some monitoring by the judiciary. That's the only thing that will keep the investigating agencies under check. Because a majoritarian ideology has crept in that affects the functioning of all agencies. Number 1. Number 2, you will not get justice unless you can ensure witness protection to the eyewitnesses and the survivors who can actually give testimonies in the court. Number 3, you must have the wherewithal, resources to generate legal aid to assist the prosecution. You must have your independent lawyers to assist the prosecution, because the prosecution can go haywire at any point of time. If you have your independent lawyers, you can present your written arguments, which have to be factored into the judgment. Lastly, try and always ensure that there's a time-bound factor to it, that these don't last endlessly. We need to ensure that such trials take place in the first 2 or 3 years, because all human beings want closure. All human beings, particularly victims of great tragedies, want to move on. So what we have to ensure somehow is a systemic recognition that it must finish, it must conclude in 2-3 years, so that you have the best evidence in place, you ensure a psychological closure, and you also get justice. You also get justice. And above all of this, we must have very intrepid and very careful documentation. Communal violence, like any other kind of violence or